Hello my friends, once again Thomas with Alpha Concepts here. Today's topic of discussion is going to be home storage of firearms in Illinois. And not just home storage, we're going to talk about vehicles, your place of business, anywhere within Illinois, how to store a firearm. You might think you know, but the law just changed a few days ago. Governor Pritzker signed a new bill, Senate Bill 8, which became law, and it's going to take effect soon, so you need to know what the new law says to store a firearm in Illinois. Okay everybody, before we begin, I just want to ask you to give me a like and a comment. That really helps the channel grow. It's free and it helps beat the algorithm. So if you wouldn't mind, just a like and a comment real quick helps out a lot. Also want to remind you, I'm not a judge, so nothing I say is legal advice. Everything I am telling you is worth exactly what you're paying for it, which is $0. So please do ask your questions. Leave any questions you have in the comments. I'll do my best to answer those questions, but nothing I'm saying is legal advice. I encourage you to read the law yourself. I'm going to link it in the description for you, but also, you want to contact your attorney with any specific legal questions. Again, feel free to ask, but my opinion is worth exactly what you're paying for it, and that's $0, so that's what my opinion's worth. And by the way, before we jump in, one last thing before we jump in. Guys, if you are interested in taking your firearm skills to the next level, I encourage you to sign up for one of our advanced firearm training classes. We have rifle, pistol, shotgun training classes. We go almost all year round, just taking off a little bit for the winter. So absolutely do that. And if you'd like to learn more about the gun laws in Illinois, then sign up for one of our concealed carry classes. We have an 8-hour seminar talking all about the gun laws in Illinois, or one of our concealed carry renewal classes. If you have a concealed carry license, you need to renew it, and we hammer the Illinois laws for 2 hours as hard as we can to make sure you understand. So absolutely that helps us out bringing you this free content. So now let's get into what the new law says against Senate Bill 8. We're going to talk about the new law. We're going to talk about some of the changes it makes to existing law. I'll give you some legal definitions so it helps you understand everything out. There are some exemptions, so we'll talk about the exemptions, and then I'll kind of just give you a summary, break it down, what I think all of that means. So jumping right in, let's just jump right in and go through and read exactly what it says. So the new act is 1040031. It's also called the Safe Gun Storage Act. If we look at that, it says storage of firearms. A firearm owner shall not store or keep any firearm in any premises where the firearm owner knows or reasonably should know a minor without the lawful permission of the minor's parents, guardian, or other person having charge of the minor. An at-risk person or a prohibited person is likely to gain access to the firearm unless the firearm is secured in a locked container, properly engaged so as to render the firearm inaccessible or unusable to any person other than the owner of the lawfully authorized user. If the firearm is carried by or under the control of the owner or other lawfully authorized user, then the firearm is deemed lawfully stored or kept. This section shall not apply if the minor, at-risk person, or prohibited person gains access to a firearm and uses it in a lawful act of self-defense or defense of another, or to any firearm obtained by a minor, an at-risk person, or a prohibited person because of an unlawful entry of the premises by the minor, at-risk person, prohibited person, or another person. So when we break it down, it says basically, in my layman opinion, that if someone gains access to your firearm, be it a minor, a prohibited person, or an at-risk person, and we're going to define what those mean in the law, if someone gains access to the firearm, then you are responsible unless it has been locked up. That's basically the gist of what that says. So you either have to store it, somehow lock it up, make it unusable, or it has to be on your person. You have to be carrying it. That's kind of the oversimplification of what we just read. So now let's talk about some of the legal definitions of what that means for a minor, what's a minor legally defined at-risk person and prohibited person. So let's take a look at those definitions. For purposes of this act, an at-risk person means a person who has made statements or exhibited behavior that indicates to a reasonable person there is a likelihood that the person is at risk of attempting suicide or causing physical harm to oneself or to others. So basically meaning if you've got someone that has some issues or has spoken about possibly harming themselves or others or making threats, this person would be considered an at-risk person according to the reasonable person. Remember, the reasonable person is the judge or the jury. Would the judge or the jury agree, or in this case, would the judge or the jury conclude that you should have known better? Next, it talks about minor. Minor means a person under 18 years of age. However, minor does not include a member of the United States Armed Forces or the Illinois National Guard. So if someone under the age of 18 has access to your firearm, unless they're a member of the Armed Forces or National Guard, they are considered a minor according to this law. So we'll talk about prohibited person next. Prohibited person means a person ineligible under federal or state laws to possess a firearm. Prohibited person does not include a person who is otherwise eligible to own a firearm pursuant to the Firearm Owner Identification Card Act, but does not at the time of the violation have a firearm owner identification card. So if someone is ineligible under either federal or state law to possess a firearm or ineligible to get a FOID card, then that person would be a prohibited person, and you'd need to keep your firearms away from that prohibited person. It also says that if the person is eligible for a FOID card but does not have a FOID card, then they would not be considered prohibited. That brings in a question is, how do you know that they're eligible if they haven't applied? Obviously, you know, if they don't have any felonies or any mental health issues or any issues with drugs or alcohol, then very, very likely they would be considered eligible. But again, how do you know? Let's talk about the penalties of this law if someone gains access to your firearm. So if we look at the law, there are a few different penalties in the law. The law talks about $1,000 if someone has access to the firearm and doesn't use it, $10,000 if they have access to the firearm and do use it, and then the law also says that you can do forced labor, community service instead of paying those fines. So let's look at that individually. The law says, except as otherwise provided in the below paragraphs. A violation of this is subject to a civil penalty not to exceed $500. But when we look at paragraph 2, it says if any person knows or reasonably should know that a minor or at-risk person or prohibited person is likely to gain access to the firearm belonging to or under the control of that person, and a minor, at-risk person or prohibited person obtains the firearm, the civil penalty shall not exceed $1,000. So we're talking about a maximum of a $1,000 fine if someone has access to the firearm but doesn't use it. So again, it's a maximum of a $1,000 fine if that person simply has access. Next, we're going to talk about what happens if they actually did use their firearm and caused harm to someone else. If we look at bullet point 3, if a minor, at-risk person or prohibited person obtains the firearm and uses it to injure or cause the death of a person or uses the firearm in connection with a crime, the civil penalty shall not exceed $10,000. So if someone stole your gun and then harmed somebody else or committed a crime with your gun, then not only are you the victim for having your gun stolen from you, but you are also the victim because they're going to charge you up to $10,000 because that firearm was not locked up. Going on, it says the court may order a person who is found in violation of Section 5 to perform community service or pay restitution in lieu of the civil penalties imposed under this section if good cause is shown. So maybe you get lucky and you don't have to pay a fine, but you're going to have to do community service. And community service could be anything from sweeping up the bus stations to donating your time at certain shelters or something like that. Obviously, that would have to be something approved by the courts. So it could mean anything. So maybe you don't get a fine, but you're going to have to do some forced labor. It's one or the other. Going on, it also says that nothing in this act shall be construed to preclude civil liabilities for violations of this act. Civil liabilities for violations of this act. Basically, you can be sued by anyone at any time for any reason, and this law says that yes, you can be sued if you violate this act. So while you might have to pay $10,000 if someone uses your firearm and harms somebody with your firearm, you might have to pay $10,000, but then the people who have been harmed or their families can come at you and sue you as well. The new Safe Gun Store Act also makes changes to the FOID law and the criminal code. So let's look at what some of those changes are so you know. Section 90 of the Firearm Owner Identification Act is amended. It makes changes to a law that is already on the books. What it says is grounds for denial and revocation. The Illinois State Police has the authority to deny an application for or to revoke and seize a firearm owner identification card previously issued under this act only if the Illinois State Police finds that the applicant or the person to whom such a card was issued is or was at the time of issuance. So that has always been on the books, but it adds a new reason why the state police can revoke your FOID card, and that is if a person who fails 2 or more times to report a loss or theft of a firearm within 48 hours of discovery of such loss or theft to a local law enforcement as required under subsection A, section et cetera, of the criminal code. So there's many reasons why your FOID card can be revoked, oftentimes at no fault of your own. This is one more time where that FOID card can be revoked. If you do not report your firearm missing or stolen within 48 hours, and you do that twice, then your FOID card can be revoked. In the opinion of the Illinois State Police or the Illinois legislature, you're not fit to exercise your right to self-defense. Going on, it also amends the Criminal Code of 2012. It adds in a paragraph regarding firearm trafficking. A person commits firearm trafficking when he or she has not been issued a currently valid firearm owner identification card and knowingly brings or causes to be brought into the state of Illinois in a vehicle or on an expressway in the state more than one firearm prohibited from possession by section 24, 1.9 per occupants of the vehicle. So if a person without a FOID card brings in a banned item into Illinois, brings in more than one banned item into Illinois, now they are subject to the firearm trafficking laws as well as importing banned items into the state. And the noose tightens. If we look at the requirement to report lost or stolen firearms, since 2014 we have had the requirement to report lost or stolen firearms. However, this law makes a change, so let's go through it. If a person who possesses a valid firearm owner identification card and who possesses or acquires a firearm thereafter loses the firearm, or if the firearm is stolen from the person must report the loss or theft of any such firearm to a local law enforcement agency within 48 hours after obtaining knowledge of the loss or theft. The report shall include the date that it was stolen or lost, the exact location where it was lost or stolen, or if the last location is not known, then the last known location of the firearm, the caliber, make, model, and serial number of the firearm, a description of the circumstances under which the firearm was lost or stolen, and the firearm owner identification card number of the person making the report. So as I said, since 2014, we've had the requirement to report that firearm lost or stolen. It used to be 72 hours, and that's why I say the noose tightens, because now it's 48 hours. You always have had to report that to your local law enforcement. However, now they include specific requirements, like I said, make, model, serial number, where it was lost, etc. So that was added in. That wasn't part of the law before. So now 48 hours from the time that you realize your firearm is lost, destroyed, stolen, etc., you must report it to your local law enforcement. 48 hours is the new timer. And when we go on talking about child protection, except as otherwise provided, it is unlawful for any person to store or leave within premises under his or her control a firearm if the person knows or has reason to believe that a minor under the age of 18 who does not have a firearm owner identification card is likely to gain access to the firearm without the lawful permission of the minor's parent, guardian, or person having charge of the minor, and the minor causes death or great bodily harm with the firearm unless. It previously was 14 years. Again, the noose tightens. That was raised to 18. So you are criminally responsible unless the firearm is secured by a device or a mechanism other than a firearm safety which is designed to render the firearm temporarily inoperable or placed in a secure lockbox or container. Previously, the law stated, which was removed with this new law, it amended and removed this portion that said if a reasonable person would believe that the firearm was secured from a minor under the age of 14. And in our concealed carry classes, we would do a mental exercise about what is a reasonable location to store the firearm. But that bullet point has been removed, and now basically the law says it must be locked up or it must be locked up. So kind of giving you my summary of what I think that this law means. Basically, it boils down to this. If someone gains access to your firearm, and let's just be broad on this, if anyone gains access to your firearm, basically you're going to be held responsible unless that firearm was used in a lawful act of self-defense or defense of others, or that firearm was stolen and you reported it stolen. Otherwise, you're going to be responsible. Again, this doesn't just apply to your home. If you have people in your car and those people have access to the firearm, you're going to be responsible. So it's probably best to keep that firearm on your person. If you have visitors coming over to your home, it's probably best to lock it up or keep that firearm on your person. If you have a firearm at your place of business, it's probably best to keep that firearm on your person and encourage your coworkers to get a concealed carry license so that they too can keep a firearm on their person as well. So again, this doesn't just about the home. This is about pretty much anywhere within the state of Illinois. If someone gains access to that firearm, you are going to be held responsible under most circumstances. There's always been a lot of questions about this because when we look at it, not a lot actually changed. Yes, definitely the noose tightened, definitely there are more restrictions, but not a lot actually changed. Illinois has always had firearm storage laws in regards to minors, as we previously discussed. It used to be 14 and it used to be 72 hours. Now it's 18 and 48 hours. But people have always asked a lot of questions about the storage of firearms. A question that I often get in our concealed carry classes is, I live with a felon, what should I do? And we would talk about constructive possession and these legal terms that, a prosecutor might make, that, the felon had constructive possession. And it was always my friendly advice that probably best to keep it locked up just so that no one can claim that the felon had access and no one can claim that you gave the felon access to a firearm. So now the law makes it very clear that yes, if you live with a felon, then the firearm must be locked up or on your person, because if they gain access, then you are responsible. Another question I get is, in the vehicle, right? What if I have my firearm in the glove box? Well, first and foremost, your firearm in your glove box is practically useless to you. So it was always my advice to keep that firearm on your person, even in your vehicle, because the reality is getting access to the firearm and using it when you've only got about a second to do that, it's just not going to happen. It's a false sense of security. But now the law makes it clear. It's either got to be locked up or it's got to be on your person. If somebody who is prohibited gains access to that firearm, you're going to be responsible. So just keep it on your person. I've got friends who, I've always got a firearm within arm's reach. I've got one under the TV. I've got one under the dining room table. I've got one behind the couch. And I always joke, I always have a firearm within arm's reach as well, and that's on my hip. To me, it doesn't make sense to stow a firearm here, there, everywhere, have a shower gun, that sort of thing. Never really made sense to me when it's just simpler to have it on your person. And yes, I do carry my firearm at home because true statistic, 100% of home invasions happen in the home. So for me, it doesn't make sense to not have that firearm. I don't have a crystal ball, and doors only keep out honest people. Yes, my door is reinforced. Yes, it's going to take some effort to get through it, but a determined person will get through it. So now with the law reading the way it reads, if you've got visitors coming over to your house, it's a very good idea to lock up that firearm or keep it on your person. And I say, unless you're, enjoying an adult beverage, it's just best to keep it on your person. That's personally what I do. I'm sure there's going to be a ton more questions. Leave any of your questions in the comments, as I said before. I'll do my best to answer them as best as I can. Remember, I'm not a lawyer, I'm not a judge, so nothing I say is legal advice. But I did spend quite a lot of time scouring through and familiarizing myself with the 50-page law, Senate Bill 8, that passed. And so I've got a decent understanding of it, plus the laws that were amended. I've been teaching for over 11 years, so I've got a pretty good understanding of that as well. Guys,
Sign up for one of our classes, one of our advanced training classes, our renewal classes. Buy a shirt. You might have noticed we've got a new logo. I'll leave a link in the description if you want to get a shirt or something like that. But honestly, I'd love to see you in class. And don't forget, like and comment, because that really, really helps out the algorithm and helps us grow. As always, everybody, be armed, be trained, and be alpha, and I'll see you in the next video.